This is Juris Stupidity, a video podcast devoted to the use and misuse of legal terms and concepts in social and other media. This podcast is on exceptions to double jeopardy protection. Very recently, the New York conviction of Harvey Weinstein, the entertainment mogul, was overturned. Though Weinstein will now be turned over to California authorities to serve his sentences there for convictions for sexual crimes, Weinstein will also likely face a new criminal trial in New York following his successful appeal. Some in the media have questioned whether his retrial in New York should be allowed given the constitutional protections against double jeopardy. In an earlier podcast, I discussed the various dimensions of protection against double jeopardy under the 5th and 14th Amendments of the United States Constitution. There are, however, some exceptions to this protection. I discuss a few of them here, and they all make sense. First, a person can undergo a new criminal trial after a successful appeal of a conviction, as long as there was no appellate finding of insufficiency of evidence. A trial after an appeal is permitted. Just because a judge may have made an error, other than for evidence, it does not give a defendant a forever get-out-of-jail card. The new trial can be viewed as basically a continuation of the original trial, only without the error or errors found on appeal. It is like there was no final determination or conviction, hence, no double jeopardy violation. Second, if a trial ends up with a hung jury, there is no double jeopardy violation for there to be a second trial. Again, this can be viewed as basically a continuation of the original trial. Third, if for some reason there is a mistrial, a new subsequent trial is not in violation of double jeopardy protection. Since there was no outcome, one way or the other, there was no completed trial. So, a retrial after a mistrial is basically a continuation of the first trial, not an exposure to new jeopardy. Fourth, civil asset forfeiture trials, while some could see them as punishment, are not even within the realm of double jeopardy. They are not criminal trials. And this status, well, it leads to our final point. Double jeopardy protection does not apply to civil trials because double jeopardy protection only applies to criminal actions. Accordingly, just because a matter can be tried again or in a different way on the same facts, it does not mean that double jeopardy protection necessarily applies. So, Mr. Weinstein will likely see the inside of a New York courtroom, again facing charges originally brought against him.